Hello everyone, my name is Ivan Chen from the Privacy Commissioner for Personal Data Hong Kong. So today, as you can see from this slide, we're going to talk about the Personal Data Privacy Ordinance. But on the other hand, I would also give a general overview about the concept of privacy and also the development of the modern privacy laws, including the GDPR that we have been talking about recent years, and how also the data economy and the data privacy are affecting each other. So first of all, we will talk about the origin of concept of privacy and how it comes from. So what is privacy? From this slide, you can see there are different definitions. From IAPP, the International Association of Privacy Professionals, it talks about the right to be let alone or freedom from interference of intrusion. While for the Privacy International, it is an NGO about the data privacy. It's more on the human rights perspective. So privacy is more on the fundamental human rights, human dignities, and so forth. Well, in fact, privacy is an all-embracing concept which covers, first of all, privacy of personal information. That's about a person's exercise of control over the information about him held by others and its use. And secondly, is about the privacy of the person, the bodily privacy, that concerns with the integrity of the individual's body, involving issues such as, body searches, compulsory provision of samples of body fluids and body issue, and biometric measurements. And thirdly, is about the privacy of personal behavior that relates to the observation of what individuals do and includes issues such as, surveillance and media intrusion. And finally, it's about the privacy of personal communication, the freedom of communicating, using various media without being monitored or intercepted by third parties. Well, some said that when talking about the origin of privacy, it refers to the, Genesis from the Bible, when Adam and his wife Eve, they were both naked at the beginning, and they were not ashamed of being naked until they had the fruit and they were aware that they need to cover themselves, cover their bodies. Well, in fact, the notion of privacy is not new. Public awareness of the need to protect privacy arose in the 19th century upon the inventions of instantaneous photography and the emergence of the newspaper industry, which had invaded the private and domestic lives of individuals. Well, the emergence of the newspaper industry and later on media industry meant that gossip was no longer the resources of the idle but had become a trade. The developments in the science of photography allowing sudden snapshots on the unauthorized circulations of portraits and pictures of private persons by commercial photographers and advertisers. The available cause of action for libel in the 19th century was no longer sufficient to protect the individual's rights because it could only provide remedy for damage to one's reputation and did not focus on direct damage to the feelings of the aggrieved persons. Against this background, the two American jurists, Louis Brandeis and Samuel Warren, published their article, The Right to Privacy, in 1890. The two authors defined the right to privacy as the right to be let alone. They also asked for formal recognition and protection of this right by the law. In 1948, the United Nations General Assembly proclaimed the Universal Declaration of Human Rights in Paris. The declaration sets out for the first time fundamental human rights to be universally protected. Article 12 of the declaration stipulates that no one shall be subjected to arbitrary interference with his privacy, family, home or correspondence, nor to attacks upon his honor and reputation. So from the rights to privacy, we can understand that it sets out the privacy right as a right to be let alone and also divides the legal remedies for intrusion to privacy rights. And from this chart, you can see the involvement of different legislations or regulations concerning the protection of privacy. First, we have the guidelines on the protection of privacy and transport flows of personal data from OECD. And then we have the EU Data Protection Directive. And based on all these, we have the Personal Data Privacy Ordinance developed and enacted in 1996. Afterwards, we have the different developments from APEC and OECD as well. And in recent years, we see the EU General Data Protection Regulation, which actually provide the updates on top of what we previously had on the data privacy regulations. So what do we have for Hong Kong? We mentioned about the United Nations Universal Declaration of Human Rights before, and in 1976, the International Covenant on Civil and Political Rights, the ICCPR, came into force. It commits its parties to respect the civil and political rights of individuals, including the right to privacy. And the application of this treaty was actually extended to Hong Kong in the same year. In the treaty, you can also see that the explicit protection of the privacy rights as mentioned in Article 17. The ICCPR applies to Hong Kong and is also recognized by the Basic Law. Indeed, the Hong Kong Bill of Rights Ordinance enacted in 1991 is a mirror image of the ICCPR. You can see from this slide that the Basic Law, Article 39, mentioned that the provisions of the ICCPR as applied to Hong Kong shall remain in force after 1997. And here, from the Hong Kong Bill of Rights Ordinance in 1991, Article 14 also mentioned the protection of privacy, family, home, correspondence, honor, and reputation. So you can see that data privacy rights as protected by the Personal Data Privacy Ordinance was not actually coming from nowhere. As you can see, the rights of privacy was mentioned and protected by the ICCPR, the Basic Law, and also the Hong Kong Bill of Rights Ordinance respectively. So coming up next, we will talk about the development of modern privacy laws. We mentioned about the OECD before. It's actually the abbreviation for Organization for Economic Cooperation and Development. It is an international organization that works to build better policies for better lives, to shape policies that foster prosperity, equality, opportunity, and well-being for all. It also played an important role in promoting respect for privacy as a fundamental value and a condition for the free flow of personal data across borders. So here the guidelines is actually called the OECD Guidelines on the Protection of Privacy and Transborder Flows of Personal Data in 1980. It is actually the first generation of data protection law, and it's commonly used privacy is also a commonly used privacy framework internationally. Here we can see there are 8 fundamental data protection principles. So you can see the 8 principles under the OECD guidelines as listed in this slide, namely the collection limitation, use limitation, purpose specification, data quality, openness, security safeguards, individual participation, and accountability. I'll go through them one by one. For the collection limitation, it refers to the personal data that should be obtained by lawful and fair means. And where appropriate, it should be with the knowledge or consent of data subject as well. And for the data quality, it is relevant to the purpose for which they are to be used and to the extent necessary for those purposes, and they should be kept accurate and complete and up to date. And for the purpose specification, it refers to the collection purpose that should be specified not later than at the time of data collection. And the subsequent use should also be limited to the fulfillment of those purposes as well. And use limitation talks about the personal data that should not be disclosed, made available, or otherwise used for purposes other than those specified in accordance with the purpose specification that was just mentioned before, unless you have obtained the data subject's consent or by the authority of law. For the security safeguards, it mentions that the personal data should be protected by reasonable security safeguards against such risks as loss or unauthorized access, destruction, use, modification, or disclosure of data. For the openness, it states that there should be a policy of openness about the developments, practices, and policies with respect to the personal data. And those means should be readily available of establishing the existence and nature of personal data and the main purpose of their use, as well as the identity and usual residence of the data controller. So talking about the individual participation, it refers to an individual that should have the rights to obtain from a data controller the confirmation of whether this data controller has access or has held the personal data that related to the data subjects, and if so, he or she should have the right to obtain a copy of it. And finally, the accountability is about the data controller that should be accountable for complying with measures which gave effect to the principles stated that in these guidelines. And the OECD guidelines was revised in 2013 with two new concepts introduced, namely the data security breach notification and the implementation of privacy management program. So specifically the requirements on data controllers are they have to implement the privacy management program. They have to demonstrate on-demand privacy management program to regulators or other accountability agents, and they also have to provide notice to regulators in case of any data breach. Here we have the EU Data Protection Directive in 1995. It was actually the second generation of data protection standard and was also an early piece of comprehensive privacy law which set down the model legal concepts for all European national laws for many years. It was later, as we all know, replaced by GDPR 2 years before, which was regarded as the third generation on the data protection standard. So from this slide, you can see the major components for the EU Data Protection Directive, namely the security of processing, data quality, the rights of data subject, and also the purpose specification. Some of them are similar to those that we have mentioned for the OECD guidelines. For example, the rights of the data subjects and also the purpose specification. You can see the further illustration and the elaboration of the different aspects here. So this table gives you a better idea on the comparison between the OECD guidelines and the 1995 EU Data Protection Directive. You can tell that the accountability aspect and also the openness aspect were not found in the EU directive. So for Hong Kong, we have Personal Data Privacy Ordinance, the CAP 486. It came into effect in 1996, and it with no surprise, make reference to the OECD guidelines and also the EU directive that we have just talked about. He established an independent authority, the Privacy Commissioner for Personal Data, and one of the major characteristics for this ordinance is that it actually covers both public and private sectors, meaning that every single data users or data controllers in Hong Kong will be governed by this ordinance, and is also one of the earliest comprehensive data protection laws in Asia. The essence of the Personal Data Privacy Ordinance, or PDPO, is the data protection principles. The 6 data protection principles, DPPs, outline how data users, data controllers should collect, handle, and use personal data, and we'll go through them one by one later. One of the most significant developments in the global data privacy arena is the introduction of EU GDPR, the General Data Protection Regulation. In 2016, the national data protection laws of the 28 EU member states were harmonized into one single set of EU privacy law, the GDPR, that was directly applicable to all member states. The GDPR came into force in May 2018. It is considered by some academics and data protection practitioners as the third generation of data protection law. The GDPR was written with the emerging technologies of profiling and automated decision-making in mind. It aims at returning control of personal data to individuals to whom the personal data belong, and imposing greater accountability on data controllers, having considered the possible impact of data processing on the interests, rights, and freedoms of consumers. Now, the major changes brought by the GDPR include the enhancements to many concepts already existent under the EU Directive in 1995, as well as some new requirements. First of all, is about the rules on extraterritorial application that has been enhanced in recognition of the global nature of data flows not limited by national borders. Secondly, it's about the express recognition of accountability as a guiding paradigm in data protection. It's exemplified by new emphasis on appointments of data protection officers, mandatory data breach notifications, and promotion of trust seals and certifications. And finally, it's about the enhanced rights for data subjects, the individuals, particularly regarding data erasure and protection against automated decision making. So here from this slide, you can see that the development of the global data protection landscape as of last year, we can see that more than 130 countries, regions, or so to speak, the jurisdictions, they are equipped with the data protection laws, while more than 30 of the others are actually planning to have their bills enacted. And while it's generally perceived that the idea and application of data protection was from the West, you can see that Asia Pacific is catching up fast. We talk about Hong Kong being the first jurisdiction in Asia having their own comprehensive data protection laws. We can see that now we have more than a dozen jurisdictions in Asia having the same data protection jurisdiction laws in their own jurisdiction, and we can see that number is growing too. Now we will talk about the major models of data protection laws worldwide. So in this session, we will talk about, of course, the EU GDPR. We'll also talk about the cybersecurity laws in the mainland of China, and also the latest consumer privacy legislations in the US. We talked a little bit about GDPR in previous slides. It's actually making data protection as one of the fundamental human rights. So the major features brought by the GDPR is that, first of all, it's actually one set of rules for all companies operating in the EU for all EU individuals. Secondly, we can see that the individuals, the people under GDPR would have more control, more power over their own personal data instead of leaving all to the data controllers or data users. And finally, businesses would benefit from a level playing field as well. Now, we all understand that with the latest technologies that would bring new challenges to the personal data privacy. So the GDPR seeks to cope with the privacy implications posed by these new technologies, and the most common phenomenon include, for example, the cover data collection by organization without knowledge, and the unexpected use of personal data, profiling, unfairness and discrimination, the retention of data, for those personal data being kept indefinitely for companies' own use, or also, the data security. So the GDPR has the following main features and changes. First of all, we have one of the major features being the harmonizing and simplifying the framework for the digital single market. And also we are putting individuals in control of their own data, as we mentioned. So all along, personal data protection is given the status of fundamental human rights in the EU. So now the GDPR provides changes to give an individual greater control over his own personal data to echo such status as fundamental human rights. And thirdly, we mentioned about that as well, is actually trying to formulate the modern data protection governance and setting up the standard for that. And finally, as seen from the recital of the GDPR, it is a balancing exercise between the protection of personal data and other interests. For example, the free flow of personal data to facilitate international trade and cooperation in light of the advancement of technology. Talking about the free flow of data, is recognized under Recital 101 of the GDPR that flows of personal data across the border are necessary for the expansion of international trade and cooperation. At the same time, personal data transferred outside the EU will be afforded with comparable protection. The Recital 101 says that the flows of personal data to and from countries outside the EU are necessary for the expansion of international trade and international cooperation. But at the same time, it also says that the level of protection of national persons ensured in the Union, meaning the EU, by this regulation should not be undermined. So here in this slide, you can see that a few quotes from various data protection authorities in EU were cited to talk about the aims and purposes of GDPR. For example, it's about restoring a sense of trust and control, putting the rights of individuals and giving the control of their own personal data, and also it's about the promoting of accountability and the data governance. So there are two major concerns on GDPR, one being the cross-border data transfer and another one being the huge fines imposed for those who did not comply with the requirements. For the cross-border data transfer, actually GDPR says that personal data may only be transferred to countries outside EU that provide an adequate level of data protection. And for the administrative fines, GDPR provides two tiers, the low one being up to 10 million euro or 2% of total worldwide annual turnover, and the higher one being up to 20 million euros or 4% of the total worldwide annual turnover. I will talk about these two aspects in the following slides. So under GDPR, we have restrictions on cross-border data transfer. The transfer is only permitted in either one of these circumstances: the adequacy decision, the appropriate safeguards, the explicit consent, and the necessity. For adequacy decision, it refers to the adequacy decision given by the European Commission to the receiving jurisdiction. So it's like the agreement between EU and another jurisdiction. For appropriate safeguards, it includes the approved certification mechanism, binding corporate rules, standard contract clauses, or approved code of practice. For explicit consent is pretty much the one given by the data subjects concerned. For necessity, it includes the performance of contract, the exercise or the defense of the legal claims, and the protecting the vital interests of individuals or the public interest. So these could constitute to the necessity aspect. For sanctions under GDPR, we talk about two tiers of administrative fines. The lower tier ones will be imposed for failure to comply with certain requirements, for example, obtaining parental consent for processing of children's personal data, the processing of personal data anonymously if it's not necessary to identify the data subjects, to give data breach notifications, or the appointment of data protection officers. And for the higher tier administrative fine, it will be imposed for those who fail to satisfy certain requirements. For example, complying with the basic principles for processing, like the lawful and fair processing or processing based on consent. Complying with data subjects' rights, such as rights to notice, rights of access to personal data, etc. And also the transferring personal data to a recipient in a third country or international organization pursuant to the lawful mechanisms. Now, after talking about GDPR, let's go to the Mainland of China. From this chart, we can see the evolvement of the data protection related legislations in the Mainland of China in recent years. It has been evolving and is evolving fast. In 2016, we can see the Cybersecurity Law, and now we understand that the formulation of the Personal Information Protection Law is on the priority list of the National People's Congress, the legislature of the Mainland of China. There are two major characteristics of the personal data protection legislations in the Mainland of China. First of all, being the emphasis of the data localization, given the concern on the stress on the national security, and second being the fragmented nature or the features of the laws. You can see that you have different laws that have personal data protection incorporated in their legislations. For example, e-commerce and data security management and the cybersecurity laws. So one of the major personal data related legislations in the mainland is the Cybersecurity Law. It was effective from 2017, and it of course only applies to the mainland and does not apply to Hong Kong. And in the legislation, it states its objectives clearly, being to safeguard the cyberspace sovereignty and to guarantee cybersecurity and to protect the lawful rights and interests of citizens, legal persons, and organizations, and so forth. So, what is the scope of application of the cybersecurity law? Who will be affected or who should comply with that? It applies to the construction, operation, maintenance, and use of networks, and the supervision and administration of cybersecurity within the mainland, and aiming to protect personal information and also regulate the network operators too. I mentioned about data localization in previous slides, and it's also one of the major features for cybersecurity law. Needless to say, the emphasis for this is about the national security, the personal information and important data collected and produced by operators of those called the critical information infrastructure during the operations shall be stored locally. And if there is any cross-border data transfer for business reasons, security assessment is needed, and as it should be conducted following the measures stipulated by the Cyberspace Administrator of China. And what are actually the critical information infrastructures? That refers to the public communications and information services, energy, transportation, water conservancy, finance, public services, e-government affairs, or other infrastructure which will cause serious damage to state security and public interests in case of destruction, dysfunction, or data leakage. Now let's take a look on the United States. Perhaps not many are aware that there's no comprehensive data protection law at federal level of US, and there's no general restrictions on data transfer in US laws at the federal level either. The reason is that the Commerce Clause under the US Constitution, which emphasizes free flow of information, practically bars any federal laws restricting cross-border data transfer. And at the state level, some states have enacted laws limiting state agencies or state contractors from outsourcing data processing beyond US borders, and the state laws are enforced by the Attorney General. The Commerce Clause states that the US Congress shall have power to regulate commerce with foreign nations and among the several states and within the Native American tribes. So, unlike other developed countries, there is no dedicated data protection authority in US either in the federal level or in the state level. So, individuals' data protection, individuals' data privacy is actually regulated by the Federal Trade Commission, the FTC, at the federal level, and there's no equivalent authority of FTC in the state level. The mission of FTC is to promote the consumer protection and to eliminate and prevent any anti-competitive, deceptive, and unfair business practices through law enforcement, advocacy, and education without unduly burdening legitimate business activity. While there's no general restrictions on data transfer in the federal level, the FTC took the view that US regulated entities remain liable for, first of all, the data exported out of the US, secondly, the processing of data overseas by subcontractors, and thirdly, the subcontractors who failed to adopt the same protections, such as through the use of security safeguards, protocols, audits, and contractual provisions for the regulated data, for example, the government information, when it leaves the US. In recent 2 years, especially after GDPR, we heard about CCPA, the California Consumer Privacy Act of the United States. It's actually passed in July 2018 and effective this year. It's being termed as the US version of GDPR. The CCPA actually provides consumers with several new rights, including the right to, first of all, to request disclosure of how data is collected, used, and shared with the third party, and the right to require for full erasure of their data. To require the disclosure of whether data has been sold to a third party, to whom it was sold, and ability to object to the sale of the data. So you can see that CCPA has given some sort of rights to the individuals, but there are some other aspects that CCPA does not cover. For example, CCPA does not contain provision restricting cross-border data flow of the data transfer. The CCPA would only also protect a consumer who is California resident, and CCPA will be enforced by the Attorney General. And now we go back to Hong Kong to talk about the provisions of the Personal Data Privacy Ordinance. We talk about the Personal Data Privacy Ordinance, the PDPO, before as one of the earliest comprehensive data protection laws in Asia. It was effective in December 1996. It made reference to the OECD guidelines and the EU Directive. The PDPO is enforced by an independent statutory regulatory body, the Privacy Commissioner for Personal Data. And the law actually adopts all OECD principles except accountability. And this law also covers both the public, meaning the government and public bodies, and the private sector. We talked about data privacy rights as the fundamental human rights and should be protected. The PDPO back to 1996 when it was enacted, the expected effects on both business perspective and human rights perspective were actually taken into account. For business perspective, it aims to facilitate the business environment to maintain Hong Kong as the financial and trading hub. And for human rights perspective, of course, we mentioned about the protection of the personal data privacy rights as the fundamental human rights. This slide shows the major characteristics of the PDPO. We always say that PDPO is principle-based, meaning that it does not, actually illustrate what it should not be done. Instead, it talks all about the requirements for those who are going to collect or use personal data. And it's also technology neutral, meaning that it can actually goes with the technological advancement when we have new technology or bring up the new challenges to the data privacy. This PDPO, this law actually can adapt to that as well. I mentioned about it, not being prohibitive nor straitjacket, and also it's also compatible to innovations. All in all, you can see that these characteristics aim to strike a balance between the protection of human rights, the data privacy rights, and also to promote the use of technology and the economical development. Now, when talking about the provisions of the PDPO, I will first of all talk about the definitions under the ordinance, and I'll go through the 6 data protection principles one by one, and together with all those case sharings. So first of all, for the definitions under the ordinance, we need to know what exactly the personal data is about under the ordinance. So under PDPO, personal data should satisfy 3 conditions. First of all, it has to be relating directly or indirectly to a living individual. Secondly, it should be practicable for the identity of the individual to be directly or indirectly ascertained, meaning that from that piece of information, you can identify a person directly or indirectly. And thirdly, the personal data should be in a form in which access to or processing of the data is practicable. So meaning it should be in a, for example, a record form, something that you can trace, something that you can access to or a process. And for data user, it means any person or any party, including private company, a government department, or a public organization that controls the collection, holding, processing, or use of personal data. They are regarded as data user under the PDPO. Whereas for all of us, being the individual, we are the data subjects. Earlier, I talked about the data protection principles under the PDPO. There are actually 6 of them. These 6 data protection principles form the base of the ordinance, and they cover the whole life cycle of every personal data. So data users, they have to comply with the requirements stated in these principles in the collection, holding, processing, etc. for those personal data that they have. From this slide, you can see the essence of the 6 data protection principles. For example, data minimization, the retention limitation, data security, and so forth. These are all the crucial aspects of personal data protection. Now here, I would like to share a court case with you regarding the collection of personal data. It is very important for us to understand what actually collection means before we go into details on the requirements under the PDPO. So this case, so-called the Eastweek case, is a landmark case of the PDPO. This case is important because it defines the meaning of collect as it applies to personal data and clarifies under what circumstances the PDPO comes into play. This case actually arose from a complaint lodged with the PCPD back in 1997, and the complainant, while walking on the street one day, was photographed by a magazine photographer without her knowledge or consent. And then the photo was subsequently published in a magazine, accompanied by unflattering and critical comments on her dressing style. And this matter, of course, you can imagine that caused embarrassment and inconvenience to the complainant amongst her clients and her colleagues and her friends. So the PCPD received the complaint and decided that the publisher of the magazine contravened the requirements regarding the fair collection of personal data. And the publisher, took this decision to the court of first instance for judicial review. But at the time, the application was dismissed. And then the publisher appealed to the Court of Appeal. And then in year 2000, the Court of Appeal reversed the decision of the Court of First Instance and also questioned the PCPD's findings. In the court's ruling, it says that the conditions for collection of personal data is that the collecting party must be thereby compiling information about an individual. And then the individual must be one whom the collector of information has identified or intends or seeks to identify. And finally, the identity of the individual must be an important item of information to the collecting party. So this case actually states the conditions for collection of personal data which we apply up till now. Now let's go to the data protection principles one by one. The first principle is about the purpose and manner of collection. So this data protection principle requires the data users to collect the personal data for purposes related to the functions or activities of the data user. For example, banks collect customers' data for the purpose of providing banking services. That's obvious. And also, the ordinance stipulates that the data collected should be adequate but not excessive. You cannot collect everything from your customers. And thirdly, the means of collection must be lawful and fair. And it is also a requirement for data users to inform the data subject of some information when they collect their personal data. Firstly, the purposes of data collection. Secondly, the classes of persons to whom the data may be transferred. Thirdly, whether it is mandatory or voluntary for the data subjects to supply the data so that they can obtain the products and services. And fourthly, whether it is a must for the data subject to supply the data, and the consequences for him or her if they do not do so. For example, if they don't provide their personal data, certain products or services may not be able to be provided. And finally, the name or the job title and address, meaning the contact method to which access and correction requests of personal data may be made. So when the data subjects, they want to raise the request of correcting or accessing the personal data, their own personal data, there should be a contact person with the contact details that they can refer to. So with all this information providing to the data subjects when collecting personal data, it is advisable for data users to use a personal information collection statement to provide those information. And then this PICS, so to speak, PICS, the personal information collection statement, should be effectively communicated. And there are certain considerations on what is regarded as an effectively communicated to the data subjects. For example, the statement layout and the languages used, whether it is comprehensible, whether it is understandable for data subjects, and also whether this personal data information collection statement has defined the purpose of use and class of data transferees with a reasonable degree of certainty and so forth. That will be something that we look for in, we expect from the personal information collection statement. Next, the data protection principle 2 is about the accuracy and duration of retention. Data users shall take practicable steps to ensure the accuracy of personal data they have, and also they need to take all practicable steps to ensure the personal data kept by them is not longer than is necessary for the fulfillment of the purpose. If a data processor is engaged by a data user, the data user must adopt contractual or other means to prevent any personal data transferred to this data processor from being kept longer than is necessary. So you can see that the law does not specify how long the data users can keep the personal data. As long as the purpose is there, as long as the personal data is needed for the fulfillment of the purpose, the data users can keep them. But they have to take practical steps to ensure that once the purpose is fulfilled, they have to erase all the personal data they have. Here I would like to share a related case with you. That was actually originated from a complaint received by our office. There was a complaint against a bank, a local bank, saying that they have engaged in the practice of retaining its customers' bankruptcy data for 99 years. And after investigation, we see no justifiable reasons for this bank to keep such data for 99 years. And when we talk about the bankruptcy data, it includes name, Hong Kong ID card number, bankruptcy number, date of the bankruptcy order, and so forth. So all these are definitely personal data, and we see no reason for such data to be kept for so long. As long as the purpose has been fulfilled, as we mentioned beforehand, they should not be kept for such a long period of time. As we know, a bankrupt will normally be discharged upon expiry of a period between 4 to 8 years. So there is no justifiable reason or a purpose for the bank to keep those bankruptcy data for more than 8 years. And after our investigation and our findings, the bank has revised its policy and not to retain customers' bankruptcy data for more than 8 years. This is a clear example of how personal data should be kept for only the purpose that they were collected originally. Once the purpose is fulfilled, they should be erased. Data protection principle 3 is about the use of personal data, meaning the purpose. We all understand that personal data is collected for a purpose. But here in this principle, it states that personal data shall not, without the prescribed consent of the data subject, be used for a new purpose. Meaning that when the personal data was collected, a purpose was stated by the data user, and therefore the personal data collected should be used for that stated purpose only. If there is a new purpose, a prescribed consent should be obtained from the data subject again, and that should be an explicit one, and that should be a new consent as well. So whenever there is a new purpose, which means there is another purpose that is other than the purpose stated beforehand, data subjects should be approached and a new consent should be obtained again. Here, I would like to share with you a case back in 2013 about a mobile app called Do No Evil. It's about an app that collected information from public domain, including the judiciary, the official receiver's office, gazette, or company's registry, and so forth. And then the data that they collected is about the litigations, bankruptcies, and the company directorship data. And these information are from the public domain that I've just mentioned. And then after getting all these data, a database was formed. And then this mobile app enabled its users to search the database for target individuals' litigation and bankruptcy data. So in short, when the user of this mobile app go to this database, they can search the target person's name and a partial Hong Kong ID number, and nature of civil cases and address and so forth. All these form the personal data of those individuals, and this information, as said, were obtained previously from the public domain. And then the argument for having this information available in a database and for the mobile app user is that these information are actually from the public domain, and they could be used to conduct a due diligence reviews and background check. However, we have to stress that personal data collected from the public domain doesn't mean that they are open for unrestricted use or for anyone to access. Those personal data from the public domain are there for a reason. For example, information from the company registry or from the transport department, they are there for people to go check for a particular reason. So if we collect data from these public domain and then use them for other purposes, that is actually in contrary to the data protection principle 3 that we just talked about, and is apparently exceeded data subjects' reasonable expectation on the use of these information. For example, the Do No Evil case that I've just talked about, I'm sure those data subjects concerned would not expect that those litigation information in public domain would be used, will be obtained in this regard, and for this Do No Evil database to compile and for people to access to. So again, as said, it is apparently inconsistent with the original purpose of these personal data collected by the data users, the judiciary, and the other relevant government departments. So again, it's not the same as the original purposes of collecting the personal data, or for making those data publicly available. So it is against the requirements of the data protection principle 3. Another significant example of the transfer of personal data is about the Octopus Rewards Limited by selling the customer's personal data to its business partners. Back to year 2010, it was found that the Octopus group actually sold the personal data for monetary gains without customers' prescribed consent, and those personal data was sold to business partners for direct marketing purposes. So apparently, in this case, the customers would not expect that those personal data they gave to Octopus groups will be used for direct marketing purposes, and not to mention that they would expect those their own personal data will be sold for monetary gains. And these kind of activities, the sale for profit, sale for gain, is not stated in the PICS, the personal information collection statement that the customers obtained beforehand either. So in short, it is not a stated purpose of data collection at the beginning, and the data user, meaning the Octopus groups, should not use the personal data in that way. Nowadays, we all talk about the security of personal data, and also one of the crucial aspects in cybersecurity is about the security of personal data as well. So here, regarding security, it also falls in the scope of the data protection principle 4, security of personal data. in PDPO, in this data protection principle, it states that all practicable steps shall be taken to ensure that the personal data are protected against unauthorized or accidental access, processing, erasure, loss, and use. So it's all about the practicable steps that the data users has taken. And the security is about, when you store, when you process, when you handle, or when you transmit the data. So it's throughout the process that the personal data was held by the data users. The data security should be ensured. Again, if data processor is engaged by the data user to process personal data, data user should again adopt all contractual or other means to prevent such unauthorized or accidental access, process, erasure, and so forth of the data. So that means, in short, the obligation of the data processor to ensure data security falls to the data user. The data user would bear all the legal responsibilities if the data processor did not follow the requirements of the data protection principles stated here. So again, there are quite a number of examples relating to the data security that we can share in the coming up slides. So the first case is about Cathay Pacific. I'm sure many of you are aware of this case. It was the data breach incident of unauthorized access to personal data of about 9.4 million passengers. It was reported after the airline found it months later. So after our investigations, we found that the airline failed to take all reasonably practicable steps to protect the affected passengers' personal data against those unauthorized access in terms of the vulnerability management, adoption of effective technical security measures, and also the data governance. So to be more specific, there are failures in a few aspects that we can share in this case. So first of all, it's about the corporate governance. The risk alertness was low, and also the risk assessment failure was found in this case as well. The vulnerability scanning exercise was too less, making it as an yearly interval, and also it failed to identify and address the commonly known, exploitable vulnerability. In operationally, it failed to have an effective personal data inventory as well. And from the technical measure aspect, the airline also failed to apply effective multi-factor authentication to all remote users. So after our findings from the investigations, an enforcement notice was served to the airline asking it to improve. Another case that we would like to share is about Hong Kong Broadband Network Limited that took place in 2018. It was about an inactive database being intruded that caused leakage of personal data of about 380,000 customers and service applicants. From our investigations, we found that there were insufficient safeguards for the database, and the company also failed to exercise control over the IT and security facilities concerned. And that's why there was a data breach that it could have been avoided with all those measures if all those measures are in place. Here we have another case concerning data security, which involved government department, the Registration and Electoral Office. The loss of the 2 notebook computers containing personal data of 1,200 election committee members, and most importantly, the 3.78 million geographical constituencies electors in 2017 had caused much concern on the loss of the personal data and the risk of exposing for illegal use. So after our investigation, we found that the security measures were not proportional to the degree of sensitivity of those data and the harm that might result from a security incident. And apparently the office also lacked the requisite awareness and vigilance as expected for protecting these personal data. So going to Data Protection Principle 5 is about the information to be generally available. Data users have the responsibility to provide the following information to data subjects. That is the policies and practices in relation to personal data, the kind of personal data they held, and also the main purposes for which those personal data are used. So again, a privacy policy in place would be helpful for data users to illustrate these information and show them to the data subjects. Last but not least, the Data Protection Principle 6 about the access to personal data is about the rights of the data subject. They can actually request the access to their personal data and also request correction of those personal data. So in short, every individual, every data subject, they can approach to those data users that hold their personal data and ask them for a copy of those personal data they have on hand, and also ask for correction of those personal data. And for data users, they have the legal responsibility to fulfill and act accordingly. And of course, they may also charge a fee for complying with these data access requests, but the fee should be a reasonable one. Here, let me share an example, a case that we have handled about a patient requesting for her own personal data. A patient, thought that she was incorrectly diagnosed by the government clinic, so she made a DAR, the data access request, to the Department of Health to ask for the copies of statements about her treatment written by the the medical offices. But then the patient was not happy that the Department of Health had redacted a sentence contained in the document given to her that expressed an opinion by the professional regarding the patient's treatment. And then the case was taken to the court, and the court ruled that a data subject is actually entitled to have a copy of his or her own personal data. But of course, that doesn't mean that it would be on every single document upon which there was a reference to the individual subject. It has to be only about her own personal data. So now you may wish to know about the penalties and offense the PDPO if the requirements was not followed and complied. Here you can see from this slide that actually, if for the contravention of DPP, the data protection principles, it is not a criminal offense, meaning that there is no criminal responsibility if you did not follow the requirements of the data protection principles. Well, instead, an enforcement notice directing the data user to remedy the contravention will be served by this office to the data user concerned. So it is you can take it as a warning letter from this office, stating what have done wrong and what you should do to make it right. So apart from the contravention of data protection principles, there are other offenses that could lead to the criminal offense. For example, we talk about the enforcement notice, pretty much like a warning letter. If the data user, after receiving this enforcement notice, did not comply with the requirements stated in that notice, that could constitute a criminal offense. So that would lead to a penalty of maximum fine of $50,000 and imprisonment. And of course, if you repeatedly do not follow the requirements of the enforcement notice, that could lead to the criminal offense as well. And then the same infringement of the second time, that could also lead to the penalty of a maximum fine of $50,000 in imprisonment. So there are certain sections under PDPO that could lead to criminal offenses. Section 64 is one of them. It's about disclosing personal data obtained without consent from data user. and the essence is about with an intent to obtain the gain in money or other property, and also to cause loss in money. And also there is another provision that if a person disclose any personal data obtained from a data user without the data user's consent and cause the psychological harm to the data subject, that could lead to the breach of Section 64 as well. And this one is a criminal offense, and the maximum penalty could lead to a fine of $1 million and imprisonment for 5 years. So here are a few examples of the breach of Section 64. For example, an individual's personal data was obtained by a company's employee, without the company's consent apparently, and then he took those personal data for sale and received monetary gain. And also for disclosure of individuals' personal data online, for unlawful purposes like bullying, intimidation without consent, that could lead to the breach of Section 64 as well. And for this one, we can actually see that in recent months there are quite a lot of doxing activities online. And when we talk about doxing, our legal basis is handling cases of such would be Section 64, because apparently we can see that the use of personal data for intimidation, first of all, is against the law. Secondly, is apparently leading to the psychological harm of the data subject concerned. Well, besides Section 64, we have another provision that could lead to the criminal offense as well. That is about the direct marketing. This requirement actually was introduced since the law reform in 2012. You can see from this slide that illustrating the regulatory regime for direct marketing. In short, the PDPO does not prohibit direct marketing activities. We are just adding the the requirements for data users to follow suit if they are using the personal data for direct marketing purposes. So here from the left, you can see that data users they have their obligations is to provide the prescribed information to data subject on what kind of personal data they're using for direct marketing, and what sort of responsibilities that they should do, and what kind of requirements that they should do before using these personal data. For instance, they need to give notifications before using this personal data to the data subject. They have to seek consent. They have to provide the options to data subjects to opt out anytime, and they have to notify the data subject again for the first time they use their personal data for direct marketing purposes. And for data subject, they have the option to give the consent. Then the consent should be given explicitly and voluntarily. So as said, failing to comply with the requirements for direct marketing will constitute criminal offenses. And the slide shows that the maximum fine for non-compliance to direct marketing requirements would lead to a maximum fine of $1 million and on 5 years of imprisonment. So besides all those requirements and criminal offenses under different sections, PDPO does provide exemptions as well. From this chart, you can see that under different provisions and circumstances, the exemptions apply. The most common ones being, for the public interest, for the crime prevention or investigation, social security and so forth, that would possibly invoke the exemptions being applied on different circumstances. With the technological advancements, especially in information and communications technologies, we believe that there is a need for us to review our current ordinance. The government and the PCPD has been working together for this, and you can see from this slide a few aspects have been identified for this review exercise as our focuses. For instance, we have the mandatory data breach notification mechanism that we would like to explore, and also we have the data retention period and also the regulation of data processes, which are not currently stated in the current laws. And for the sanctioning powers and the powers for criminal investigation and prosecution, that actually goes to the enhancing the powers for the PCPD to better enforce the law and protect the personal data privacy. And talking about the definition of personal data, it also goes hand in hand with the trend in the international data privacy arena by revisiting the definition and how it can cover and address to the latest need. And for the regulation of disclosure of personal data of other data subjects, that actually refers to the recent doxing behaviors online, and we would like to see how we can better deal with that with different new measures and implement it. After talking about all the laws and the data protection legislations, let's look at the data economy and the privacy. Now, I think this slide best illustrates what the data economy is all about, and all different aspects have come into play for this. Now, we all agree that data is the lifeblood of the data-driven economy we now live in. Through collecting big data and conducting subsequent analytics, decision-making models are often built to replace human decisions and make automated decisions, with the goal of improving the quality and efficiency of products and services. Now, this trend, however, has proven to possibly be problematic and disruptive. Here you can see some examples of AI and big data applications, such as the personalized recommendation in marketing, virtual assistant in recruitment and medicine, credit scoring and virtual banking in finance, and so forth. And here are more examples on how AI and big data applications are used in our daily life. And AI was also applied by the hospitals in Hong Kong to examine chest X-rays. Now, more examples on AI and big data applications. Now, one of the most well-known examples of misusing big data and big data analytics is the Facebook and Cambridge Analytica incident. Cambridge Analytica allegedly harvested personal and behavioral data of millions of Facebook users and then constructed profiles of American and UK voters. Now, using these profiles, analysts at Cambridge Analytica were allegedly able to deliver personalized propaganda materials to targeted groups of individuals with a view responding to their concerns and nudging them to vote for the 2016 Trump presidential election campaign or the Brexit referendum leave campaigns. Now, of course, we can find enormous economic value for AI applications. You can see that it brings improves the efficiency in information processing and decision making. It simplifies the processes such as the recruitment and electronic identification and so forth. And it also enables business innovations such as provision of personalized user experience and streamline advertisings and so forth. And of course, it would help increase the accuracy as well. Well, of course, apart from the benefits brought, big data analytics and AI also have negative impacts specifically on data privacy. The lack of transparency in AI algorithms makes it difficult for individuals to fully comprehend when, how, and to what extent their information is communicated, as well as the full extent of privacy consequences. And the evolving algorithms in big data analytics and AI are unpredictable and may generate surprising results which could be sensitive and private. When AI was fed with inaccurate and irrelevant, incomplete or unrepresentative data, the results and the predictions made from the analytics may well be inaccurate and or biased, leading to discriminatory decisions. Anonymized data released for big data processing and analysis could lead to unwanted re-identification of data subjects. And of course, the individuals could also lose control over their own data. As mentioned, in the Facebook and Cambridge Analytica incident, big data analytics could cause manipulation of human behavior as well. So all these negative impacts directly conflict with our privacy principles. Now, specifically on those privacy principles, big data analytics and AI thrive on enormous amounts of data being collected to produce profound insights. So that runs counter to the principle of data minimization. Also, AI are able to extract meaning from data beyond the original purpose for which it was collected. That runs counter to the principle of the purpose specification as well. Besides, automated decisions made by algorithms may be difficult to explain, limiting organizations' ability to be transparent. The inaccurate predictions by big data and AI analytics and subsequent decisions that may adversely, affect individuals could run counter to the principle of data accuracy. And all the possible adverse effects of AI and big data analytics may impact individuals' fundamental human rights beyond privacy intrusions. For example, the freedom of speech, freedom of election, and so forth. Now here you can see more examples regarding the biases and discrimination generated by the misuse of AI. Now, besides behavioral and personality data, audio and visual data of individuals may also be misused. Now, deepfake is a technology which utilizes artificial intelligence to process data and in turn composite highly realistic but fake images and video. We can see some of the examples here as well. Well, in essence, such misuse of data and AI technology may make it easier for blackmail, spreading misinformation, and more. Here we can also find an example of unfair predictive credit scoring as reported by the FTC. According to the FTC, the creditors using algorithms to profile and assign credit risks to individuals who shop at certain stores based on the default histories of other shoppers frequenting the same stores. Individuals' credit score, the credit score could be unfairly lowered due to the aggregate data despite their good individual payment history. And in Hong Kong, Securities and Futures Commission (SFC) issued guidelines on online distribution and advisory platforms in July last year. The guidelines apply to all SFC licensed and registered persons when conducting regulated activities in Hong Kong, in providing order execution, distribution, and advisory services in respect of investment products via online platforms. So you can see from the guidelines, Chapter 4, that relates to the offering of robo-advices, that the applications and requirements are listed here as well. So all in all, data users, when they are using AI and big data, they should ensure transparency, explainability, and human intervention. When talking about transparency, we're talking about keeping customers informed of the use of AI, and also they should have the privacy policy and practice in place to let the customers know. And for the explainability, the data users should explain to customers the operation of AI and the rationale and the assumptions behind, so that the customers are fully aware of that. For human intervention, as we are aware, and judging from the previous examples as well, the AI and machine learning may make mistakes. So we should not let AI to make final decision, and human decision or intervention is important. In the coming up slides, I will talk about the previous concerns in smart city developments and 5G. We understand that nowadays there are various smart city initiatives all over the world, and all of them, more or less would use a lot of data. So, what does that mean to data privacy when we talk about the smart city development? That leads to a few concerns in terms of data privacy. For example, it's about the surveillance, whether that will be over excessive collection of personal data, whether there will be discrimination for for the results generated from data collected and all that. So Hong Kong, we have our smart city blueprint issued in 2017, and the objectives is to pursue the smart city development by making use of innovation and technology. So various initiatives like the encouraging the use of open data and data analytics for the public services is one of them. And these are the development plans under the the government's smart city blueprint. And I'm sure many of you are aware of the smart lamppost that has been in place since last year, and with the pilot ones being built in the East Kowloon side. So the smart lamppost at its initial stage would be for the collection of data involving weather conditions, air quality, and that will be used for the the infrastructure for the Wi-Fi and 5G networks as well. Here is the illustration from the government regarding the various features of the smart lamppost and the applications. And you may notice that different government departments are collecting data via this smart lamppost, while some of the features and functionalities are not fully in place or applied yet due to the previous concerns. So when we talk about smart lampposts, we also understand that there are some controversies regarding how much personal data were collected and what is the use of those data and so forth. So when we talk about smart lampposts, how the government, how we can explain to the public about the use and how transparent we can and how capable we can in building trust will be crucial to the success of the implementing smart lamppost initiative, and that involves the whole process from installation, from how the technology was chosen and adopted, and what are the parties involved, and how they're related to the project, and the most importantly, the collection, use of the personal data, and how they will be shared, to whom they will be shared, and all that. This information will be crucial, for enhancing the transparency and all in all about the explainability. Now, another functionality that of people's concern nowadays is about the facial recognition. We understand that this these functions can be applied to CCTV applications as well, and it's getting more common. And whether that would lead to previous concerns would depend on how these data would be collected and how they'll be used. So here we list out the various concerns and the principles that we should observe. For example, when applying the facial recognition, we should clearly articulate the purpose for using that, and we should address the concern, and we should also stress the why we need that, and whether there will be other less privacy intrusive alternatives that have been considered but were at last not adopted, and whether there will be any risk of misidentification and how we can mitigate that and all that. So a good practice for CCTV or facial recognition is that we should state the legitimate aim. We should have that purpose in mind, and also we should always remember, and also bearing in mind that we have to meet the public expectation in privacy, or at least to let them know, to explain to them, and including why this is adopted, and whether there will be other less privacy intrusive means have been considered, and we should have a proper and a proper way to notify the public and how these CCTV or facial recognition was used, and that would include whether this is used for what purpose. And then again, we need to state the appropriate data retention period, after which those data will be erased and be taken out, and what kind of security measures are in place, and how we could deal with the in case of any data leakage, etc. Now here are a few considerations, and in terms of the CCTV or facial recognitions, about the identification. For example, about the image resolution, how high resolution that it should be, and whether that there is a need to recognize a human face, and then for example whether we need a visual camera or a thermal camera would be sufficient, and also the video or the image, how they could turn into numerical data, and then or how the images can be blurred so that there will be no issue or less privacy concern of that, and also how we can ensure there will be no re-identification by backward re-engineering. The following few slides are about 5G and the privacy concerns brought. I'm not going to go into details of the technical bit, but simply speaking, 5G would be a new generation of the cellular network that could bring a faster connection time and with a greater capacity in transmitting data and so forth. So that undoubtedly would bring much potential for new business models and the way data will be used. And of course there are some negative impacts on the data privacy possibly brought by 5G as well, including the ubiquitous connection, the location privacy, and also the security issue of mass connection. 5G is about always available, so it's about constant connectivity anytime, anywhere, and that could mean a mass amount of data collected and transmitted through different channels and means, including many IoT devices like the smart lampposts that we mentioned, and the smart home appliances and so forth. However, with such continuous tracking and monitoring, and with such big an enormous amount of personal data generated, that could bring up privacy concern that we need to be aware as well. And of course, when we talk about the people's personal data, how they can be kept anonymous, how they can be kept secured, is also an important issue that we need to be aware of. Location privacy. Anytime, anywhere, and personalized service would mean a lot of location data, tracking of the data subjects being generated, and that could also mean more precise location data being tracked and collected as well. Now, one thing we need to be aware of is about the mismatch between the volume and sensitivity of data. We all know that under 5G there will be a lot of data being transmitted, being handled, being generated as well. So how could those risks of unauthorized access and security breaches of sensitive personal data being mitigated? That will be an issue that we need to pay attention to. So all in all, it's all about getting it right for the 5G applications. There's no way for policies and laws and regulations to catch up fast enough, but I think we should at least ensure we are comply with the requirements under the current laws and regulations. And also as the developers of 5G or the data users, the 5G users, besides being complied with the legal requirements, and they also have to adopt the good practices and data ethics, and with all those data protection principles in mind, and those will have been mentioned throughout the presentations, like data minimization, transparency, and explainability. And of course, the privacy by design and privacy by default will be the key principles that the 5G service providers should observe, so that while when they design or they implement any new initiative, they should know that privacy protection should be built in at the very beginning. With all the privacy issues and implications we have mentioned, at this final part, I would like to talk about the accountability and data ethics as the solution. This picture actually illustrates how the legislation and public expectation can be breached by the allocation of accountability and data ethics. We know that it takes time for legislation to catch up with the technology development and to address all those privacy issues and concerns. And given the technology development, a lot of data will be collected and processed as well. So in that regard, accountability and data ethics can serve as the bridge to bring the public expectation, to bridge the gap between the legislation and public expectation. The relationship between ethics, laws, and accountability can be seen in this graph. Laws would not be the only tool for us to protect personal data. There are, of course, legal obligations for data users to follow and to comply with. But all in all, it's also the accountability and ethics that matter. So what exactly is accountability? It's more than the legal compliance that we have been talking about. It's about the responsibility for the data users to put in place the adequate policies and measures to make sure the good practice are in place. And the rationale being that data users with their power, with their capability, are actually in the best position to identify the embedded privacy risks and how they can address that. Back to 2014, the PCPD introduced Privacy Management Program. It's a voluntary accountability framework, and at the beginning, the pledging organizations include all government departments and bureaus, and also more than 30 commercial and public organizations from different industries, including insurance and public utilities and so forth. There are three major components in PMP. The first one being the organizational commitment. We stress the buy-in from the top. It should be the policy and the focus coming out from the boardroom, and also the appointment of data protection officers who should also be a part of the senior management as well. And again, the establishment of the reporting mechanisms for all the privacy-related issues should also be in place. And the second major component is about the program controls. Here you can see 7 different elements under this program controls, covering from the personal data inventory, the handling of data breach, to the training and communications as well. And finally, it's about the ongoing assessment and revision that goes to the oversight and review plan, and also the program controls and the continuous assessment and revision of that. Here, we would also like to introduce a very important concept, data ethics. It's about more than the legal compliance and more than the accountability. It's about how the data users can think ahead and plan and execute with the multi-stakeholders approach, and how we can get the data management right from the cradle to grave basis. And of course, we should have the system and process in place and revisit them regularly. So data ethics is taking a multi-stakeholder approach in protecting personal data, and it also talks about the consideration and respect for the rights and interests of all stakeholders, and that includes the individuals. And individuals, the data subjects, their data rights should be protected and respected as well. And here we introduce the ethical accountability framework, which is similar to what we have just mentioned about the PMP regarding the top-down approach. First, we talk about the values and the principles and policies in protecting personal data, and then we should put it in place, and then we have the systems and policies and the procedures in terms of the assessments and oversights. So for the values, in the ethical accountability framework, we stress on 3 values: the respectful, beneficial, and fair. For respectful, we talk about transparency. Data users should be transparent and provide individuals with their own control on their own personal data. For beneficial, it should be an approach which helps identify and assess risks and benefits to all stakeholders. That includes data users and data subjects. And whenever there is risk, we should think of how we can mitigate them. And the third value, being fair, is to avoid bias and discrimination generated from for example, AI and big data applications. So for principles and policies in the framework, principle is an expression of values in business context. So here is an example for customers not being excluded from being served due to the inaccurate profiling KYC. For policy, is also a translation from values into enforceable procedures. So, for example, we need a fair policy in place. And finally, for the assessments and oversights, for the ethical data impact assessment, we need to identify and assess the impact of data processing activities on all stakeholders. And again, as mentioned, we should mitigate the negative impacts if there is any. And for the process oversight, we need independent assessment on the integrity and the effectiveness of the organization's data stewardship program. So how this should be implemented? We are talking about the combination of privacy by design and ethics by design. First of all, we need to know about the business objective and also the purposes of the data processing activities involved. And then we need to assess the nature, source, accuracy, and governance of the data. And afterwards, we should conduct the impact assessment. So this is similar to the privacy impact assessment that we have been advocating for long. We should know the risks and benefits involved to all stakeholders, to the individuals, to the society, and of course to the data user itself. And finally, we should strike a balance between what the benefits we can get, the expected benefits, and also the mitigated risk, and not only to one party but to all stakeholders. So this slide shows the involvement of data ethics. You can see that data ethics was firstly discussed at the ICD PPC meeting held in Hong Kong back in 2017. 1 year later, the PCPD issued the Ethical Accountability Framework for Hong Kong, China in the same conference. And in Brussels, the same conference also issued the Declaration on Ethics and Data Protection in Artificial Intelligence. So subsequent to this declaration, a permanent working group on ethics and data protection in AI was formed. This working group is co-chaired by data protection authorities in France, in EU called the European Data Protection Supervisors, and Hong Kong. Last year, we also see the European Commission issued the ethics guidelines for trustworthy AI, which serves as a very good reference to the same subject. So here we have cited a quote from the previous Commissioner for Personal Data, Mr. Stephen Kai Wong, about the data ethics on AI, which, as mentioned, was firstly discussed in Hong Kong back in 2017. Here we mentioned about the new digital ethics, and we also mentioned about the equitable privacy right for all stakeholders. This actually served as a very good basis for us to explore further and discuss further in the coming up years on data ethics. Here I would also like to share with you the a circular by the Hong Kong Monetary Authority last year. After speaking with them, HKMA has issued a circular to all authorized institutions, the banks and financial institutions and all that, encouraging them to adopt and implement the ethical accountability framework that I've just mentioned in developing their fintech products and services. So that serves as a very good example how the data ethics concept was implemented and put into in different business exercises. And I talked about the Declaration on Data Ethics before, back into Brussels in 2018, the ICD PPC conferences. A few core principles were named here and listed here. For example, the fairness principle, ethics by design, and the empowerment on every individual, and so forth. So last year, there is the ethics guidelines for trustworthy AI issued by the European Commission. Here they have 7 key requirements that actually were built on the principles mentioned in the declaration as well. For example, the privacy and data governance, the transparency and accountability, and so forth. So with the data ethics in place, we see that we can have the trust from stakeholders, and also we can enhance our brand and reputation and competitiveness. So all in all, that would for sure benefit data users as a whole. And the golden rule is treat privacy as human rights, and then you would put much respect on that. Here, I would also like to talk about PCPD's roles being the enforcer, educator, and facilitator in protecting personal data privacy. All these are also our strategic focus as well. By enforcing the law fairly, by engaging to different stakeholders, by incentivizing data users, we can actually promote the compliance, accountability, and in turn, ethics, trust, and respect. So all in all, would generate the privacy-friendly culture. And speaking of incentivizing and engaging, we'll try different means and initiatives to encourage the data users to do better than simply following the legal requirements. For example, we will acknowledge them by certification. We will highlight the practical benefits by respecting personal data privacy. We'll engage them in dialogue so that we can hear from them firsthand about the difficulties, challenges in putting data protection in place. And of course, we will have the practical assistance offered to them, the guidance and training and different programs.
And finally, as the fair, enforcer of the PDPO, we also have the enforcement policy being, no unwarranted naming and shaming, so that they know that we are trying to resolve the disputes and trying to help them by doing better in data protection. So after all, as we have mentioned before, it's all about a balanced exercise between protecting individuals' rights, upholding countries' interests and data protection, and then on the other hand, to promote the ICT development and to encourage the free flow of information, and also to enhance the economic and trade development. So that's all from my presentation today. Thank you once again for your time. If you have any questions, please feel free to call us and email us, or go to our website to look for the most updated information. Thank you very much.